Welcome to We Get Work and the Year Ahead 2024 podcast series. Covering workplace issues from both subject matter and industry perspectives, the 19 episodes provide both big picture trends and detailed tactics that can help employers achieve their workplace ideal while remaining real about regulations, compliance challenges, and more in 2024. Jackson Lewis invites you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series on whichever platform you turn to for compelling content.
Good afternoon, and thank you for joining us for this special episode of We Get Work for the Year Ahead 2024. Today, we're talking about the 2024 Leave and Accommodation Marathon. I'm Katharine Weber, and I'm joined today by Joe Lynett and Patty Pryor. I hail out of the Cincinnati office, along with Patty Pryor. Joe, on the other hand, works with our New York City office, so Patty and I get the opportunity to beat up on him pretty frequently. So we picked this topic because we know that there were many developments in 2023 with respect to the Americans with Disabilities Act, the Pregnant Workers Fairness Act, Family Medical Leave, you name it, all things leave and accommodation, there were developments. And of course, we know that there's more of the same to follow in 2024. So this will really be a marathon for employers. It'll be the 2024 Leave and Accommodation Marathon to be ready and to be compliant with all things 2024 has to share with us. It's like a race. And you know what my favorite race is? The race to see when the PWFA final regulations are finally issued by the EEOC.
Hey, Joe, you know what my favorite kind of regulations are?
What kind, Patty?
The ones that get delayed.
So then you are really loving these final regulations then, because they are now officially delayed. We were all ready to unpack hundreds of pages of anticipated regulations under the PWFA the Friday night leading into the New Year's Eve holiday, and they were never released.
Is it fair to say they're overdue?
I think they are.
All pregnancy jokes are on the table. That's all I'm saying.
As I said, the ones that never get issued are actually my even more favorite regulations.
Well, we did get a little bit of a reprieve. Our understanding is that the interagency review through the Federal Office of Information and Regulatory Affairs received the text of the final regulations for review on December 27th. Assuming that the EEOC's final regulations clear this review, we expect the regulations to be published in the Federal Register very soon.
Well, final regulations or no final regulations, we've been helping clients defend against EEOC charges alleging violations of the PWFA for months now. The law became effective June 27, even though we had no regulations. And right now, we're just operating under the proposed regulations. And we know that the PWFA is a priority for the EEOC. In fact, the new EEOC General Counsel just said yesterday in her first press conference that the EEOC litigators around the country stand ready to enforce the PWFA. I don't know about you, but I feel pretty warm and fuzzy about that, Patty. What do you think, Joe?
I'm not feeling so warm and fuzzy about that.
Yeah, neither are our clients. And from a practical perspective, we've already been seeing the PWFA be a hot topic. And in fact, for employers who receive a PWFA charge, they can expect to also see an allegation that there was a violation of the Americans with Disabilities Act and the PDA as well. And if the charge covers an issue that the EEOC is going to try to push the contours or the bounds of the law on, you should also expect to see a request for information related to all accommodations requested for the past several years under the ADA and the PDA, and of course since June 27 of last year for the PWFA. Given that employers should expect the EEOC to be very aggressive under the PWFA, I really think employers should take this time to make sure that their PWFA request forms, their healthcare provider forms, their interactive process forms, that all of those are up to date and ready to withstand EEOC scrutiny. So that's my PWFA spiel. Joe and Patty, what are you guys seeing with respect to the frequently asked questions from our clients under the PWFA?
Well, the PWFA borrows many familiar concepts under well-established laws like the ADA, the PDA, and Title VII. So a lot of employers have just expected to carry forth those very familiar concepts like reasonable accommodation and the discrimination theories that can be had under these laws. But to say the PWFA borrows the reasonable accommodation concept from the ADA can be a bit misleading, and clients are struggling with this because it doesn't quite work the same under the PWFA. Under the ADA, you have to be a qualified individual with a disability in order to receive reasonable accommodation. You have to be able to perform the essential functions of the job with or without reasonable accommodation. The PWFA is very different. Employees who are limited by pregnancy, childbirth, and related medical conditions many times will have to be treated even better than employees who are disabled under the ADA. And what I mean by that is that an employee who is limited by pregnancy, childbirth, and related medical conditions doesn't necessarily need to be able to perform all of the essential job functions in order for the employer to be required to provide reasonable accommodation. And that is a concept that employers are unfamiliar with because they've become so familiar with the standards under the ADA to provide reasonable accommodation. And under the ADA, where an employee is unable to perform the essential functions of the job with or without reasonable accommodation, they're not qualified under the law, and therefore there's not an obligation to provide reasonable accommodation. It's very different under the PWFA. This is an area that we addressed in Jackson Lewis's comments to the proposed regulations, and we hope to see some clarity around this issue.
I'm certainly hoping the EEOC listened to our questions and responded to them appropriately. Another area I'm seeing some overlap between the PWFA and other laws is between lactation under the PWFA and the obligation to provide breaks and a private space to pump under the Pump Act. Under the Pump Act, it's pretty clear what employers have to do for employees. Under the PWFA, obligations much broader and not so clear. For example, we've been hearing a lot of employees who want to bring their babies into the workplace to breastfeed them or work from home so they can breastfeed in private. At the end of the day, there's a lot to untangle when it comes to the overlap between these two laws as well. If employers can work with employees to find solutions that work for everyone, that's obviously the best path. But it's not always doable. Knowing the legal limits of what is required is going to be an absolute necessity. Of course, PWFA is not the only thing hopping right now. Let's talk about some other issues. Joe, what do you think else is top on mind?
Well, it continues to be the growing trend of expanding leave laws and leave entitlements, particularly state and local paid sick leave laws. And the struggle is real. So I don't think I'm telling or saying anything new on this. It's just that we have each year when we look to find out what's top of mind for employers, for our clients, this is an issue that we repeatedly come back to. So it's sort of more of the same. And just kind of an illustration of how complex leave has become is a recent example in the city of Chicago, the state of Illinois, and the county of Cook in Illinois, where they all have competing legislation on paid leave. And we have an entire team of Jackson Lewis attorneys trying to help our clients with employees in those jurisdictions because there are overlapping requirements within these jurisdictions, right? Within the state, local, and city jurisdictions. And of course, with the new year comes a new legislative session. So many bills are being introduced at the state and local level concerning leave entitlements. Here in New York, Governor Hochul announced yesterday that she is proposing paid prenatal leave care as an amendment to the state's paid family leave law. It's an additional 40 weeks of leave for prenatal care, and it covers time off before the child is born. Currently, under the New York paid family leave law, leave can be taken only after the child is born. So, this is just an example of this time of year. There's a lot of legislative activity around paid leave entitlements, and the continuing mosaic, tapestry, collage, however you want to describe it, of leave entitlements is growing ever and ever more encumbered and complex. So that is top of mind for employers.
So, Joe, how do multi-state employers who are trying to keep up with all of these different state and local laws, how do they keep up with this dumpster fire?
Well, employers have to find a trusted source that's on top of these new laws that come out. So we help employers stay on top by offering our leave-and-accommodation suite. It's a proprietary software program that we've developed here at Jackson Lewis over the years. It tracks all various state and local leave laws. And we now even have clients for whom we are tracking paid sick and paid family leave bills each month so they can look around the corner and see what's coming. It's really fascinating, but exhausting for employers to try to keep up with this. So employers that can have a turnkey solution, their life will be much easier.
So what about the federal paid family and medical leave or federal sick leave? Do you think we'll actually see it?
Patty, who knows, but I doubt it. The reason why we have all this activity on the state and local level concerning leave entitlements is really to fill the vacuum that Congress has let continue in terms of legislation around leave entitlements. Congress is, of course, working on it, but they've been working on that issue for years and haven't found common ground.
Yeah. And it will only be helpful for employers if they actually then preempt all the other state and local. Otherwise, it's just an additional headache thrown on. Another issue I think I'm seeing employers really struggle with this year is the increase in religious accommodation cases. After SCOTUS came in last summer and issued the Groff decision, we've seen an increase in cases and a lot of challenges for employer. What's a sincerely held religious belief? What's an undue hardship? What do we have to accommodate? Are all questions that many employers are dealing with now for the first time. And I think it's going to be more challenging this year in 2024 with the presidential election coming up, SCOTUS continuing to kind of wade into challenging territory, and whatever else catches fire on social media, employers are going to have to tread carefully. In fact, at her press conference, the new EEOC General Counsel said the agency is carefully watching for signs of discrimination against employees based on the ongoing conflict between Israel and Hamas. You can completely see how sensitive of an issue this could be. For instance, what if one of your employees has a Pray for Israel sign on their Zoom background and another shows up on the same online meeting wearing a Free Palestine t-shirt, and they both complain about the other?
So what does the employer do in that setting?
Call us.
Patty, that is an awesome way to wrap up this segment. If you have any questions about anything we've talked about today or just want to talk through how to handle an employee's request for leave of absence or accommodation request, just call the Jackson Lewis attorney with whom you typically work, and we're happy to help.
Thank you for joining us for the Year Ahead 2024 Special Edition podcast series. Please tune in to our next episode where we will continue to tell you not only what's legal, but what is effective. All of our Jackson Lewis podcasts are available to stream and subscribe on Apple Podcasts, Google Podcasts, Libsyn, Pandora, SoundCloud, Spotify, Stitcher, and YouTube.